Top 10 things in-house counsel should consider about AI. My name is Alan Friel. I'm the chair of Squire Patton Boggs Data Privacy, Cybersecurity, and Digital Assets Practice. Before I introduce our presenters, I have a few housekeeping items to mention. First, we are recording today's program. During the presentation, all participants will remain in listen-only mode. We'll be circulating the materials as well as the recording in the days that follow this session. If you experience any technical difficulties, please send a message via the Q&A panel, which is located on the lower right of your screen, and ask for assistance from the host. This will be picked up by our IT support team. We've scheduled approximately 10 minutes to answer questions at the end of the session. Please use the Q&A function and select all panelists to ask a question directly to our team. If we're unable to answer your questions due to time constraints, we'll follow up with you shortly afterwards. We'll be offering continuing education credit for this webinar. Stay tuned until the end of the program when we'll provide the code needed to obtain credit. This is the first in a series of AI webinars by Squire Patton Boggs, with the latter events to take a deeper dive into specific topics. Today, to stay informed on AI issues and webinars, subscribe to our Privacy World blog. We have 10 presenters today representing multiple practice groups, including data privacy, cybersecurity, and digital assets, IP/IT, corporate, labor and employment, litigation, and public policy from 5 countries in all 3 of our primary regions, US, EMEA, and APAC, all of whom are deeply involved in counseling clients on AI issues. After the presentation, you will receive a practical guide with 10 issues for in-house counsel to consider in advising their businesses on AI. For purposes of this webinar, we've combined some so as to cover 5 primary topics noted here. So with no further ado, I turn it over to Julia Jacobson to set the stage for us. Julia?
Thank you, Alan, and thank you to everyone in our virtual audience for joining us today. We're very excited to present to you today. So the kickoff, of course, is defining artificial intelligence, and a lack of a uniform definition is one of the things that makes laws and lawmakers have such trouble coming up with a uniform law that could apply generally. So the way I like to think about what is AI is, in the broadest sense, it's a combination of a whole lot of data and computer code that's designed to solve problems. But I think it's important to understand AI as part of a continuum. One end is the artificial general intelligence. That's machines that think and solve problems like humans, like all the futuristic TV shows, C-3PO, perhaps. And at the other, by the way, I looked up yesterday and found out that experts say that achieving artificial general intelligence is somewhere between, wait for it, 20 years and a century away. So that's a big time period. But at the other end of the spectrum are the algorithms that just solve simple4everyday problems, like our digital assistants, the Alexa, perhaps. So on the screen, you'll see 4 different definitions that were chosen because they sort of represent some of the complexity in defining. The purple font is what I think is the most different about them. But I think the autonomousness of the autonomy of the artificial intelligence is the commonality among all of them. And the OECD one seems to be the one that the regulators are relying on most, as my colleague Wolfgang will discuss in about 5 seconds. The European Parliament seems to have based their definition, or their provisional definition, of what is AI on the OECD definition. So if all else fails, turn to the OECD definition, at least for now. So with that, Wolfgang, do you want to take over and take us on a tour?
Thank you, Julia. Yes, with pleasure. So hello, everyone from Brussels. It's a pleasure to be part of this group to discuss AI in from many different perspectives. My view, or my perspective, will be on law and regulations, and in particular policy around AI. I'm not sure how many of you have read last week's Economist. I think in it you saw a nice update where the CEO of OpenAI, so the company behind ChatGPT, that needs no introduction anymore, he called for tighter regulation of this rapidly developing generative AI, because he thought, if this technology goes wrong, it can go quite wrong. And he delivered that message to US senators. And this week, this gentleman is touring Europe. So he's meeting with the top political echelon in Spain, in France, in Germany. So they all, and he's not the only leader in that space calling for the form of regulation. Now, the good news here is that AI is already partially regulated. You have, for example, in Europe, the GDPR, and my colleague Charles will later kind of talk a bit about the interaction between the AI out there and the GDPR regime, and other sectorial laws which apply to an extent. And obviously what you can see and what you will hear from me is that the regulatory momentum, the policy debate around AI is in full swing, because I think, and I'm a public policy partner and therefore policy nerd, I think it's one of the key unsolved questions, policy questions we have, how to regulate AI, this extremely fast moving technology. Now, the European Commission has basically given it a try, and has proposed 2 years ago a very broad-scale regulation for artificial intelligence use cases, the so-called EU AI Act. Some of you may have heard about it, for others this may be new. Now, 2 years on, we have seen this proposed law advancing slowly but steadily in the European Parliament, and between the member states. And that's relevant because those two institutions need to agree on one joint text, single text, for it to become law. And we're very far advanced in these discussions. We do expect an adoption of a final law in 2023. So I think at that stage, it's going to be very relevant for all of us and you to take a close look at what's in this proposed law. Now, it is, as I mentioned here on the slide, it's a very broad-scale regulation of AI use cases. It has a very broad scope as well. So it will cover providers of AI solutions which put their systems on the EU market, or they put them into service, regardless of whether they are based in the European Union or outside. So, it may not be the perfect example here, but think of GDPR in terms of, extraterritorial scope this new EU AI Act will have if you're in that space. And even if you're a user of an AI solution, you may be in scope, because as soon as the output produced by this AI system is used within the European Union market, the scope of this law will likely apply. I have to add likely because we're in the final stages of that law. What's interesting, I think, also about it, if you take a closer look at this proposed law, is it introduces a risk-based approach that has different risk categories. There's a category which is called unacceptable risk, so something the European Union would not like to see being used and being offered to its citizens, because it contravenes EU values and violates fundamental rights. And that would include social scoring, or also the exploitation of vulnerabilities, for example, of children or otherwise disabled persons, and other vulnerable groups. So this will be, and this category of unacceptable risk kind of has stayed steady. So there will be unacceptable versions of AI use cases at the EU level. I think where the real discussion is on is the high risk category. So high-risk AI systems, in the definition or in the thinking of the European Commission, there are two main groups. One is those are systems which are a safety component of a product. Think of a car. Then AI is used to increase the safety of that car, and that product is already subject to a third-party conformity assessment. So if that's the case, then this high-risk AI system, or this AI system, is deemed high risk, and I'll talk later, what it means if you're high risk. The second category is the European Commission itself has already designated certain AI systems as high risk, and the European Parliament has now added a few additional kind of areas where they think it's high risk, and those are AI use cases where people's health, safety, or their fundamental rights could be adversely affected. So that could, for instance, be the usage of AI systems in recruitment, in HR, in the evaluation of your staff, for instance, in educational context, when you screen candidates for the hiring processes. But the Parliament has also added a few additional areas. For example, if biometrics are involved, if insurance companies use AI, if AI is used by children, if it's generative AI, so here's our ChatGPT inclusion, deep fake AI, general purpose AI. So all of this would be deemed high risk. Now, what does this mean if you are high risk, if you are using or a provider of a high risk AI solution? Well, such solutions can only be placed on the EU market, or they can put into service if they comply with certain minimum requirements, okay? And before you can place them on the EU market, you must subject it to an ex ante conformity assessment. That means you have to get approval for that solution before you place it on the market. And such a conformity assessment has to be repeated if there are substantive changes or modifications made to the system. And in certain cases, you also need an independent notified body which is involved in the assessment process. And beyond that, you need to implement a quality, a risk management system with a wide range of obligations. So it's a very cumbersome, a very burdensome probably place to be if you are providing such a high risk AI service. And it also kind of comes with certain risks when you get it wrong. So think of GDPR. The potential sanctions of getting it wrong are in the 6% of global turnover revenue space. So something I think kind of very relevant to look at. Then there are two, maybe with the previous slide, if we can stay at the previous slide for one more minute. There are two additional kind of categories. One is limited risks. So that's risk, for example, impersonation when they are bots. So here, kind of the law will foresee a requirement to make sure people know that they're talking kind of, or they're interacting with an AI. And the fourth category, which is not mentioned here, is minimal no risk. The European Commission thinks that the majority of current AI use cases kind of will be carrying minimal or no risk, and there will be maybe at maximum voluntary guidelines. I will leave the UK and China and other many jurisdictions kind of to my colleague Julia to cover.
Thank you, Wolfgang. I'm going to focus just for quickly on the Canadian AI and Data Act. It's still under consideration. It was introduced in July 2022, and interestingly, a companion document was released by the Canadian regulators in March of this year that focuses almost entirely on high-risk AI systems. So it's picking up on a lot of what Wolfgang said. It focuses on systems that screen people for services or employment, biometric systems, systems that can influence human behavior at scale, deepfakes, and systems critical to health and safety, like a self-driving car. And it has the usual governance, transparency requirements, not dissimilar from what Wolfgang talked about: system assessment, risk management, anonymization of data whenever possible, record keeping, and some hefty fines, and a lot of latitude for the newly created or agency to create regulations. So, but it's mostly the fines that are worth noting. They are GDPR-esque, a lot of similar to what Wolfgang was talking about. And now we're going to actually talk about a law that is in effect, which is the New York City biometric law, and it also has the same kind of requirements. It's focused almost entirely, however, on employment, and it has some requirements for it's called Automated Employment Decision Tool, their definition for an AI-esque system, and it requires an annual audit. and a summary of they have to publish a summary of a bias audit on the web page, and you have to provide advance notice before you're going to use the AEDT. And rules were adopted on April 16th, and they have some relatively helpful explanations for how to do a bias assessment. Query whether this New York City law will become a de facto national standard given the size of New York. So just something to think about and maybe take a look at it. More commonly, consumer protection laws. The FTC has issued several blog posts or alerts focused primarily on kind of what I call fake AI claims that something is AI because people think it's fun and sexy when it's not any different than what was provided immediately before. And then deep fakes and dark patterns. So those are the kind of FTC's key issues from a consumer protection standpoint. And the state's consumer protection regulators are also getting into the act. IP laws. This is a whole webinar in itself, just raising it. Privacy and security laws. Ellen introduced that a little briefly, as did Wolfgang. The data that's going in, is it personal? And how do you protect it? There's a lot of what was underlying the ChatGPT, let's just call it craze, following the Italian regulator announcement of its ChatGPT's ban. And I think Charles will be talking a little bit more about that. These voluntary frameworks are actually very helpful when you're trying to come up with some kind of internal policy or procedure. They're, again, not necessarily binding. The OECD is the oldest. You know, ISO, always a good source of very prescriptive requirements. NIST has a risk management framework, so it's focused mostly on risk management versus, you know, definitional type, you know, high risk, low risk. It's much more focused on risk management. There's a White House, the US president issued an AI Bill of Rights, and Singapore has an AI Verify, which I believe my colleague will be talking about in about 5 or 6 minutes. And then we have the regulatory guidance. There was a UK white paper, pro-innovation, as Wolfgang showed at the bottom of his slide. The US EEOC, the Equal Employment Opportunity Commission, issued some sort of guidance about use of AI to assess job applicants and employees. So theme here, at least in the US, job applicants and employees, use of AI. It's a big regulatory focus. And then the FTC had these various blog posts about, you know, are you exaggerating what AI is? Are you actually using AI, or are you just using it as a marketing tool? And also a lot about deep fakes and their potential danger and how important AI is to creating them. And so with that, I will turn it back over to David Naylor.
Going to David Naylor in London and Stacey Swanson in DC to address AI policies and frameworks. David.
Thanks, and hi, everyone. As we've seen from that quick review from Wolfgang and Julia, many jurisdictions already regulate the use of AI to an extent at least, with potentially significant sanctions for infringements. And in addition to potential legal exposure, there are, of course, reputational risks for businesses that are perceived to use AI unethically. So companies, therefore, really have no option but to implement an effective AI governance framework now. And it is this topic that Stacey and I will be discussing during this part of the session. The starting point when developing a governance framework is that you have to know what the business is planning to do, and frankly, probably already doing, in the area you are looking to put controls around. This means building processes to capture information, not only about the AI tools that your people may be building or using, but also the tools that are being bought in. And to do this effectively, you need to identify the people within the organization who are likely to have a role in the development, use, or acquisition of AI tools, and build a reporting process to capture this information from them, and potentially, if you can develop the technology, from the resources they're specifically using. It's also critical to capture this information early in the process, particularly in relation to any potential uses of AI that may now or very soon be unlawful. To ensure that's done effectively, you need not only to know what the state of regulations are in the jurisdictions in which you operate, but because the environment is developing so rapidly at the moment, to regularly conduct horizon scanning to ensure you stay ahead of the game. Stacey, you follow policy and legislative developments in the US. It'd be great if you could share some insights in terms of where you're currently seeing legislative momentum.
Thank you, David. So Washington policymakers, particularly the congressional lawmakers in Washington, D.C., are actually very slow to move on enacting federal laws that address growing concerns over AI. And that's essentially because there's a knowledge gap on Capitol Hill around the fast-moving new technology. And so that's the most significant obstacle for advancing AI federal legislation here in the United States. However, policymakers, as Julia alluded to it, in the U.S. are keenly aware that private and public entities are already using automated systems to make critical decisions that could impact individual rights and opportunities, such as hiring and firing of staff, housing, credit opportunities, and other goods and services. So in the absence of a federal law to rein in AI, federal agencies are increasingly showing an appetite to engage on perceived discrimination and bias in automated systems. This includes issuing guidance to remind employers that existing laws and statutes still apply to the use of automated systems. Meanwhile, the U.S. states are stepping forward and legislating on AI. And as Julia noted, New York is at the front. California and Texas are also states that we would recommend that you watch because they tend to be key politically heavyweight states. And they will be giving you a little bit more insight into what Republicans and Democrats might have on the table with respect to AI and legislating. So in New York, as Julia already mentioned, apart from that, there's several other proposals that they've been considering. New York is a Democratic-controlled state. They've been looking at proposals that look at ensuring algorithms that are tied to data and data privacy have a meaningful human review component to advertisements having to disclose the use of synthetic media, and proposals that use security cameras supported by AIs in New York classrooms, which obviously have some privacy components as well. In Texas, where we have a Republican-controlled state, the state house passed a bill in April that would establish an advisory council to monitor the rise and adoption of AI. Among other things, the state council would assess the biases that might be present in AI systems, but it also includes a reporting component on whether AI systems have been used at the state capacity as an automated final decision system that may or may not include a human decision maker. So some key takeaways when you're looking at what's going on in the U.S. is AI is fast evolving and largely unknown. Lawmakers in the U.S. Congress and at the state level are trying to understand it and somehow install guardrails. Similar to other tech policy shifts that we've seen in the United States, AI policies are likely to emerge as a patchwork of laws at the state level, which means horizon scanning is key for companies to keep abreast of emerging AI state laws and possibly federal laws. Horizon scanning is also important globally, especially where the United States may downstream collaborate with other countries on AI concerns. So back to you, David.
Thanks, Stacey. Alan, could we have the next slide, please? So with everything that Stacey's just said in mind, we'll take a quick look, and it is, with apologies, a really high-level look at a few more key aspects of an effective AI governance framework based on our experience from building these for a number of clients. First, you not only need to identify and then weed out potentially unlawful AI uses, but you also need to develop processes to identify potential development or use of highly regulated AI systems. These are the highly regulated systems, for instance, that are described in the EU AI Act and in other pieces of legislation that are following the EU's lead. So teams working on these kind of systems, the highly regulated ones, need to understand that their ability to use them may actually be constrained, and that certainly there will be compliance costs, potentially material compliance costs, involved if the business decides to proceed. Doesn't mean the business shouldn't, but those costs need to be weighed in the balance before a go, no-go decision is taken. Too often we see businesses implementing highly regulated systems, only subsequently seeking compliance guidance, which can be an extremely inefficient and expensive approach. Next, given the application of GDPR across the UK and Europe, and GDPR-like laws in many other countries, companies should pay careful attention to uses of artificial intelligence for profiling or automated decision-making purposes that may have a legal or similar effect on individuals. Examples might include use of AI to filter out applicants for jobs, or by landlords when selecting tenants, and so on. In the absence of meaningful human oversight of such decision-making, affected individuals will typically have a right to prevent or take action in respect of such uses of AI. So automated decision-making, ADM, needs to be carefully understood and reviewed and implemented appropriately. Let's turn now to training data. Businesses need to be aware that there are potential IP, contract, data privacy, computer misuse, and other legal risks with using data scraped from the web for purposes of training AI models, and certainly also data privacy issues to consider at the very least when using even your own customer or employee data for AI training purposes. In addition, using biased or inaccurate data sets will be potentially unlawful, as well as quite likely to result in AI tools generating unlawful decisions and content. So any effective governance framework needs to implement controls around the acquisition and use of training data. We could take a whole session or more to discuss those risks. There isn't time, unfortunately, but David and Kyle, I think, will be touching upon some of the contracting issues to keep in mind when acquiring AI training data and tools. Most developed data privacy laws, just moving on to the next point, and proposed AI laws incorporate requirements for impact assessments to be carried out in relation to new and potentially intrusive processing activities. And that applies both in connection with data privacy and will apply in connection with deployment of AI. So the governance framework that you put in place needs to implement processes bearing in mind the requirement to consider the risks from the perspective of data subjects and other potentially affected individuals. These are not just the risks that affect the business, as well as looking at the risks from the perspective of partners, customers, and suppliers wherever that's relevant. And those impact assessments that you conduct should focus on identifying and mitigating risks to a level that's acceptable, and they need to be fully documented. And if you can't get to a point where any risks that have been identified have been mitigated to an acceptable level, businesses should not proceed with whatever they're planning to do. It's likely to be unlawful. It's also important to diligence third parties with which you may be collaborating. It's especially the case here in the UK and in the EU, as well as other jurisdictions, including some US states like California, where it's already a legal requirement to diligence any entity you engage to process personal data on your behalf, which of course will frequently be the case with providers of, say, SaaS-based AI solutions. In addition, you need to remember to ensure that any mandatory terms between controllers and processors, for example, those terms that are required under Article 28 of GDPR, are included in your contracts. And as a final point, it's obviously critical to implement a quality assurance process to monitor the output of your AI, to ensure it continues to operate effectively and generates consistently reliable, high-quality results. And while we're on the topic of consistently reliable and high quality, I'm going to hand over to my partner, David Elkins, to introduce the next part of the session. David, over to you.
David, did we lose you? Kyle, do you want to pick up?
I'm sorry, I had myself muted, Alan.
Yeah.
Thought I took it off. So thank you, David. David Elkins here. I lead the firm's intellectual property and technology practice. And in this part of the webinar, Kyle Fath and I will identify the potential landmines hidden in generative AI inputs and outputs, and how to mitigate them through careful commercial contracting. My colleagues, as David the other David was just discussing, have already touched on some of the regulatory and privacy related issues or landmines that might impact the use of generative AI. I'm going to add some color to the IP related landmines that may lurk. Kyle will then discuss how best to mitigate all types of AI landmines through careful contracting. So first, we need to discuss generative AI input landmines. And in general, discussion of AI inputs refers to the use of images, literary works, written text, and so on in data sets. Image data sets and large language models, or LLMs, can include items that are subject to third-party copyrights, for example, for literary works and images, and rights of publicity for personal image rights. As everyone, I think, on this webinar understands, just because something is on the internet does not mean it is free to be used in a commercial manner without the permission of the copyright owner. For example, we need to go back to the prior slide. Next. Well, this one, right. For example, when preparing the slide, I wanted to use an image of a landmine field, and I searched for a good image, found one, and I purchased it before using it to make sure that I was not, or the firm was not infringing somebody's copyright. Some data sets are curated, taking into account the rights of third parties, and when they include materials that are owned by third parties, they're licensed from their owners. But that's not always the case, as some AI platforms are based on data sets containing all manner of protected third-party content. For example, Stable Diffusion is said to include billions of tagged images. And those images were compiled through scraping the web without regard to the copyrighted nature of the content. So the key issue to be determined, at least in common law countries, but also in many other countries, is whether the use in data sets of materials subject to third-party rights qualify as a non-infringing fair use in the US or fair dealing in the UK. Those concepts are also exist in other countries as well. The two concepts are pretty similar. They both arise in certain circumstances, such as satire, commentary, teaching, and news reporting. In the US, it can apply to a transformative use in a manner for which the copyrighted material was not intended. As several lawsuits have received a lot of press, certainly in the US, based on the use of copyrighted material in data sets. Whether the defendants will succeed in establishing a fair use by essentially proving a transformative use is uncertain. I think certainly those of us in the States saw the Supreme Court's recent decision in the case between Andy Warhol and Lynn Goldsmith, a photographer who had taken some photographs of Prince that Andy Warhol treated in his usual creative way. Supreme Court said that that was not sufficiently transformative to qualify as a fair use. Justice Kagan, in her dissent in that case, asked rhetorically, if Warhol's treatment of the photos is not transformative, what is? That's an open question. Another landmine is the fact that copyright infringement cases, certainly in the States, can be very expensive. So even putting aside for the moment privacy and regulatory issues that our colleagues previously noted, AI users ignore IP landmines in inputs at their peril. There are also some landmines in the use of generative AI outputs. In Germany, the US, and other jurisdictions, copyright doesn't apply to generative AI outputs because copyright only applies to human-authored works. The UK provides protection for computer-generated works, but who owns the resulting work is a little bit ambiguous. I think the UK law provides that the owner is the person who makes the arrangements necessary for the work's creation, but is that the person who created or owns the AI platform, or is that the person who used the AI platform to generate the work? And that issue has yet to be sussed out. Now, ownership of generative AI outputs may not be critical to many users, but others who need to enforce ownership of outputs, IP law currently either does not provide for it, or at least does not provide certainty. Bottom line is that the best way to avoid generative AI input and output landmines, whether IP, privacy, or regulatory based, is through carefully crafted commercial agreements. And that's what Kyle Fath will walk us through now. Kyle, over to you.
Yeah, thank you, David. I'm Kyle Fath, partner in our Los Angeles office. Delighted to be here today. And yeah, David's exactly right. Combination of addressing these issues properly in commercial agreements, as well as during the vendor diligence stage, maybe even before you get to negotiating the contract, carrying out a proper assessment and understanding exactly what an AI vendor is going to be doing for you. And certainly a lot of what I'm going to be talking about, I'm going to be assuming that we're talking about from the perspective of a business procuring an AI application software solution. One of the key things is going to be figuring out from your business, what is this application doing? Luckily, AI is a sexy thing right now, and they're going to be excited about it. They say, this vendor's, this is an AI vendor. They're doing AI. And you're like, well, what exactly are they doing? You have to dig deep and figure out what is the application exactly cover, what kind of data is being processed, what is the input, what's the output. And so, David Naylor already talked quite a bit about what's the source of training data and some of the risks that can arise from that. I think the only thing I'll add, and I think this was also touched on by what David Elkins said, by training data, we mean more than just data like words and numbers. It can be images, videos. Some of you may have seen the AI created beer commercial that was trained on videos of other beer commercials. It was almost like a dystopian hellscape of a beer commercial, but it was very entertaining. AI systems can be trained on all kinds of things, not just words and numbers, data. So we talked a bit about the source of training data. One of the big areas that needs to be diligenced and addressed with respect to AI vendors are ongoing rights to your company's inputs. I think, put another way, will the vendor be using your inputs to train its algorithms and AI systems? Certainly vendors will sometimes commit to that verbally or maybe even in documentation. But if that is not contractually committed to by the vendor, they may temporarily not use your data to train their algorithms. But if it's not set in stone in the contract, there's likely nothing stopping the vendor from doing that. One of the areas that you'll have to diligence in an assessment and then also cover in the contract is who's responsible for historical and ongoing testing of both maybe inputs and outputs for bias and discrimination. Depending on the type of system, the accuracy and reliability of the outputs, what in the lawfulness, etc. You have to address that in a diligence early on and cover that in the contractual, in the contract. A couple of other things that may be relevant in certain applications are, whether the vendor provides features to enhance transparency or explainability to end users. And that'll be important to understand whether, the AI will be used by end users in the first place. Are the end users your internal employees, or will it be used by your customers? For example, like, are you engaging a chatbot vendor and they're going to be communicating with your customers, perhaps on your websites and other platforms? And so when we say transparency, what does that mean? Explaining to end users that and making them aware that they're interacting with an AI system, like in the chatbot scenario where you often see, hey, this is an automated system, or they have a cute little name to allude to that you're chatting with a bot. Explainability, at least a good example of what I've seen, it means in part, I think, give you an example. If you look at ChatGPT, they very clearly disclose the limitation that the data it was trained on goes back to only a certain period. So, it's communicating limitations on its capabilities, which then informs how accurate the output may be. To the extent you have end users that are going to be interacting with an AI system, you'll want to know whether you have the ability to provide a customized user experience so that you can address issues like transparency and explainability and maybe other issues. Another issue that is worth addressing, if personal information, personal data are implicated, especially if you're going to be inputting the personal data, or maybe end users will be inputting personal data into an AI system, is whether and to what extent the vendor will be able to assist you with privacy compliance, such as honoring privacy choices, deletion requests, and so on. Certainly covering all these different factual scenarios and addressing them with obligations and understanding the specifics of what the vendor does to make sure that things memorialize in the contract. Of course, at the end of the day, back to like nuts and bolts contracts, make sure you have reps and warranties covering, non-infringement, for example, that the training data was acquired lawfully, that your lawful use of the AI system will not violate laws, for example. And of course, you would also want to consider, standard provisions like shifting liability through indemnification, addressing limitation liability. At the end of the day, an AI vendor is a commercial contracting vendor, and you want to address standard provisions as well. And so I'll now pass it on to my colleagues, Charles and Kristen.
Thank you, Carl. So here, basically, the idea is to give you a sense of who will be coming after you if things are going wrong. And on the US one, first, I think it's important to have a sense of what will be the enforcement framework under the upcoming AI Act. And a couple of my colleagues earlier on already mentioned the similarities with GDPR. Here as well, the upcoming EU AI Act will be enforced in a kind of decentralized way, meaning that each member state will be responsible to enforce non-compliance with the Act. So it's a GDPR type enforcement with GDPR type fines. As we are celebrating the 5 years of GDPR, that probably tells us a couple of things or where we will go. I think there will be challenge in enforcement because of that decentralization. We will likely see that different regulators have a different agenda, and enforcement strategies might therefore lead to a kind of puzzle. But even more worryingly, probably, as in most member states, the data protection authorities will be the one responsible to enforce AI. There will be a question of staffing, budget, and capabilities. One of the main components under the EU AI Act is to be able to prove that you have cybersecurity robustness in the product and in the solution that are put on the market, someone will need to test that. And it remains to be seen whether the European data protection authorities will have the resources to get there. Important also to keep in mind is that, of course, the EU AI Act will be coming at one point, but there is already, as we mentioned, other avenues to try to tackle non-compliance with in relation to AI uses. And in the EU, certainly, we have AI as a technology and certain AI use getting a lot of attraction for regulators and courts. I'll just mention a couple of them. You see some sector-specific actions. For example, in the financial sector, you have a lot of European agencies who have been looking at AI use in for example, trading or in financial services more broadly. Currently, they are in a kind of wait-and-see mode, still publishing guidelines, best practices, and but you also have other initiatives, like the one from the European Commission itself, who created recently an EU Center for Algorithm Transparency. You have other enforcement by data protection authorities, such as enforcement by the Guarantee or the CNIL in relation to OpenAI. And you have even more far-reaching calls for accuracy and transparency in a number of automated decision-making that are relevant for the purpose of enforcing AI solution. One of the examples is a case from the Slovak Constitutional Court, where basically AI was used to track a taxpayer that were in need to be investigated because of their behavior. In that case, the court went very far in asking the public sector to come up with transparency requirement and explain how the system was working for the taxpayers to be able to understand what was happening. Finally, with AI will probably comes a lot of AI liabilities, and that might be something that will be picked up by a couple of activists to try to go for collective redress. We know that class action is probably not so common in the EU compared to the US, but there will be probably an attempt to go that way. And Christine, maybe you can then explain the US way. Thanks.
Great, thank you, Charles. So AI is certainly also an area of focus in the US at the moment, with a rise in both federal regulatory scrutiny as well as civil litigation, particularly in the class action context. So as Julia mentioned, notwithstanding that there is no federal law specifically regulating the use of AI in the US, it certainly has been a priority, particularly in relation to the Federal Trade Commission, or the FTC. So the FTC has enforcement discretion for Section 5 of the Federal Trade Commission Act, which generally prohibits unfair methods of competition in or affecting commerce. So insofar as its enforcement discretion under Section 5 is concerned, the FTC is certainly focused on AI-related deception, both in terms of exaggerated and unsubstantiated claims for AI products, as well as the use of generative AI for fraudulent purposes. But the agency has also cautioned that the design or use of a product can violate the FTC Act if it's unfair, which certainly can arise in terms of AI tools being used with biased or potentially discriminatory results. with the FTC warning as recently as this month that the increasing use of technologies powered by machine learning can raise significant privacy and security concerns, as well as implicating these other considerations. The FTC's focus in this area is particularly noteworthy, as some of the penalties available at its disposal can include, in certain instances, algorithmic disgorgement, whereby the companies that have been targeted in those enforcement actions specifically have been forced to delete all algorithms, resulting either whole or in part from the inappropriate collection and use of certain personal data. On the litigation side, the plaintiff's bar is certainly also in the US targeting companies that use AI, including in relation to facial recognition products and other technologies, with a high volume of claims being filed, for instance, under the Illinois Biometric Information Privacy Act and others. And certainly the use of AI raises other nuanced issues that are likely to be implicated in civil litigation in the US in the near future, with several early cases already filed, including, as my colleague David Elkins noted earlier, in the IP context. So certainly this includes, based on my experience and those of others at the firm, in the realm of data security, intellectual property and trade secrets, and additionally as well as state laws governing deceptive marketing and trade practices, with a growth in all of these types of claims anticipated in the near future. So certainly these lawsuits will be important to watch for companies that are creating or using AI tools and technologies, but more fundamentally to mitigate risk. It's absolutely essential that entities using such tools adopt mitigation measures, including those that Kyle Fath covered. So with that, I'll turn it over to, I believe, Sarah and Shar.
Kristen. So hi, everyone. We're going to move swiftly to the last theme that we're going to be talking about in this webinar today or tonight, and that is to treat AI governance as both a business and a compliance imperative. So, we get it, right? ChatGPT, GPT-4 has gotten your C-suite really excited. There's been a bit of a buzz. But the question is, how do you as general counsel engage your stakeholders in a constructive way, but at the same time addressing and mitigating, managing all those risks we've been speaking about? And the answer lies pretty much in AI governance, right? So we've talked a little bit about that, but I'm going to kind of deep dive into it a little bit and talk about the Singapore Model AI Framework. Here I've drawn two concentric circles, and that really is to depict that AI governance helps you achieve compliance, and so therefore it's a subset, but it also goes beyond. And what do I mean by that? So compliance is about following a fixed set of rules that are essentially formulated externally by some lawmaking body. Governance, on the other hand, is more self-determinative. So it starts with the fundamental question, how do we hold ourselves accountable for AI? Compliance is also state-specific, right, essentially. But governance, on the other hand, is what I call supranational. It transcends state boundaries and state laws. So, this whole AI governance topic is also pretty close to my heart because Singapore, which is where I'm from and based, was the first country worldwide to publish a model AI governance framework. And this was back in 2018, and it was at the World Economic Forum Summit in Davos, Switzerland. A second edition has since been released in January 2020. And essentially, an AI governance framework is built on principles. So there are foundational principles. And then on top of the principles, you have the framework itself. And then on top of that, which is what you will shape and influence by way of the framework, will be the practices that an organization adopts with regards to AI development or use. And looking at the Singapore model framework, the principles are twofold. One, decisions made by AI should be explainable, transparent, and fair. And the second principle is AI should be human-centric. So in terms of, what you need to consider for the framework itself, the Singapore model offers 4 buckets. So the first is internal governance. So this is setting clear roles and responsibilities within your organization around the use of AI. The second is determining the level of human involvement in AI augmented decision making. So is it human in the loop, human over the loop, and preferably not human out of the loop entirely, but that's something to think about as well. The third is operations management. So, how do you minimize bias from training data sets? And the last is stakeholder communications, which are essentially measures that you have to ensure transparency and explainability as per the principles. Julia mentioned earlier, there is a self-assessment checklist, and it's all available online, so you go have a look as well. And I think the bottom line is that there is a growing repository of resources out there, right? We are seeing the OECD, NIST, we're seeing ISO, IEC, there is also the Global Partnership on Artificial Intelligence, or GPAI. They have a working group and they come up with reports as well. In fact, today, there are more than 70 jurisdictions worldwide with national AI policies. And as you can imagine, they are constantly evolving, right, very quickly. So on top of that, right, we also have additional sectoral industry guidelines that govern AI. So it's a lot. So it's really quite timely to get yourself started on AI governance. But I think ultimately it is really important to tailor your framework so that it is workable for your business. And with that, I'm going to hand it over to Sarah Bellotti, who will be discussing how AI compliance can impact the valuation of your business.
Thank you very much, Sherman. So let me add a brief view from a pure corporate transactional perspective. So compliance is not only a legal obligation, but it's also an economically accessible value. We are witnessing an increasing sophistication in the metrics of assessing the value of tech companies. Indeed, when it comes to approaching extraordinary transaction, whether M&A, private equity, or venture capital, one of the main parts of the due diligence concerns checking on whether a company is complying with applicable regulation with reference to its digital assets. So investors are interested in evaluating the compliance of products or services sold by companies. In other words, it's a matter of evaluating the assets that a company offers to the market and in relation to which, of course, it obtains its revenue. But not only, investors now also evaluate the compliance of digital tools used internally by companies in their process. So when we say evaluate, we mean for all intents and purposes to assign an economic value to compliance, or rather to non-compliance. So how you can calculate the value of non-compliance? So basically, it's about estimated costs needed to be compliant in the future, plus the risks associated with the non-compliance in the past. So that the sum of these is an amount that could be actually discounted from the value of the company. Therefore, from a pure transactional perspective, we assess compliance as an asset itself that can impact a lot to the economic valuation of the company. And with this, back to you, Alan.
Thank you. I'm going to jump ahead before I wrap up and give people the CLE code in case they've got to jump on another call. It's AI524, AI524, and I'll return to this slide in a moment. Now back just on takeaways and the wrap up. I think this is our overview presentation. We've got another 7 webinars that go into the elements of a program and how to conduct assessments in much more detail and in certain contexts like employment and so forth. What we're hoping you take away today is the need to understand what's going on, the context and use of the AI, the inputs and outputs and how the processing works, what the laws are that apply to the use case and how to comply with them, determine when notices need to be provided and to whom, contract and shift liability where appropriate, and document the assessments to better establish that the AI system is used in a manner that the benefits outweigh the potential harms. We will be circulating to you today the slides, as well as some guidance material that go into these takeaways in more detail. We appreciate your time today and look forward to seeing you at other webinars in the series. Again, the CLE code is AI524, and CLE credit will be available in these US states, as well as England, Wales, and Ireland. So thank you for your time today. We look forward to working with you. Feel free to reach out to any of the presenters or your Squire Patton Boggs relationship partner for more information.